Hi everyone. So my name's Elizabeth Ridley. I'm a solicitor and I work within the Public Law and Human Rights Department of Owen Mitchell Solicitors. I'm based here in the Manchester office and I'm here with my colleague Helen as well. So today's talk is going to be applying the law to get better outcomes for your clients or your patients. The training will cover the Mental Capacity Act 2005. I'll go over what's meant by mental capacity, also what's meant by best interests. Then I'll talk a little bit about the MCA in practice, deprivation of liberty, and then when we come back from the break, I'll talk about the overlap between mental health and community care, a brief overview of the Care Act, and then I'll finish off by talking a bit about the best legal avenue that you might want to go down for your clients should they have a multitude of issues facing them. So that's a lot to get through, but what I wanted to do is give you an overview of key statutory provisions so that you can look at your patient's care holistically and try and get the best outcome for them. So, the Mental Capacity Act 2005. What is the Mental Capacity Act? So it was passed by Parliament in 2005. It covers England and Wales. It applies to people over the age of 16. So often there's confusion with people thinking that it only applies to people over the age of 18. It doesn't. It applies to people over the age of 16 who may not be able to make decisions in one or more areas. The decisions that you might be looking at can cover a number of different areas because capacity is decision specific. So for example, you may have an individual who is unable to make decisions in relation to who they can come into contact with, whether they can engage in sexual relations for some of your purposes, whether they can manage their medications, whether they can consent to a specific operation, whether they can consent to share their medical information with family. So you might have a situation where it's clearly in the patient's best interest for family to be able to take them to medical appointments or help them get their prescriptions, and they may well lack capacity in that specific area. Whether to make decisions in respect to their care, and so on. And the MCA Code of Practice states that it will empower people to make decisions for themselves wherever possible and protect people who lack capacity by providing a flexible framework that places individuals at the very heart of the decision-making process. So the idea is that it's very person-centred. So why do we need the Act? An estimated 2 million people in the UK lack capacity to make decisions for themselves. Making decisions on behalf of somebody who does lack capacity in a specific area can be really, really difficult for family members, for care staff, as to know what to do. So before the MCA, there wasn't actually a statutory framework for decision making, so it's a really important piece of legislation. The Mental Health Act of 1983 did cover assessments, treatments and rights of people with a mental health diagnosis, but it has quite limited powers in comparison to the Mental Capacity Act. The Powers of Attorney Act 1985 did also enable a power of attorney to be created, but this was very much limited to financial and property decisions, and it's covered by the MCA now in any event. So I've put here the general principles of the MCA, and these can be found in Section 1 of the Act. So firstly, a person must be assumed to have capacity unless there is evidence, i.e. a capacity assessment, to rebut that presumption that they do have capacity. Secondly, a person is not to be treated as unable to make a decision unless all practicable steps to help them do so have been taken without success. A person is not to be treated as unable to make a decision merely because they make an unwise decision. And a decision made on their behalf must be done in their best interests. And finally, before the decision is made, regard must be had to whether the purpose for which it is needed can be as effectively achieved in a way that is less restrictive of a person's rights and freedom of action. So what is meant by mental capacity? Well, under Section 2 of the Act, you'll find the first part of the capacity test. This is often referred to as the diagnostic test, and a person is unable to make a decision for themselves, i.e. they lack capacity, if at the material time they are unable to make a decision for themselves in relation to a specific matter. So you can't generally lack capacity, it's got to be you lack capacity in what area. And that has to be because of an impairment or a disturbance in the functioning of the mind or the brain. So there has to be a nexus there. There was a very recent case of North Bristol NHS Trust and R, 2023. And in that case, the judge quite helpfully set out that this provision does not actually require a formal diagnosis, even though, confusingly, it is often referred to as a diagnostic test. Under Section 3 of the Act, you'll find the second part of the capacity test, and this is often referred to as the functional test. It's split into 4 limbs that I've set out for you there, and this is that a person has to be able to understand information, retain that information, use or weigh that information, or communicate their decision. And in relation to communicating decisions, it's worth noting that this doesn't have to be verbal communication, it can be sign language, etc. So in relation to the using and weighing information limb, this is the one that we quite frequently see kind of trips up clinicians and assessors of capacity assessments. It can be really, really nuanced and really difficult to pick up. So if you've got somebody who is not understanding information, that might be quite apparent. If you've got somebody who's quite forgetful and can't retain information, that also might be quite apparent. And also if somebody can't communicate information, you can see that. But for somebody who may only fall down on the limb of using and weighing information, they might not get picked up as easily. So there was a really recent case that I thought showed this really well, and this was the case of North East London NHS Foundation Trust and Beatrice 2023. And in this case, the trust applied for a court order to state that Beatrice, that wasn't her real name, but her care plan, including the stopping of psychiatric treatment and a referral to palliative care by the trust, to be lawful and in her best interests. Mr. Justice Moyston states that Beatrice is 50, she is a highly intelligent woman, she has an under and postgraduate degrees, and he goes on to say that she has suffered from anorexia since she was 14 years old. She has also more recently been diagnosed with autistic spectrum disorder. And when the case was heard, Beatrice only weighed 31.9 kilograms and her BMI was 11.5. A normal BMI for a healthy female is 18.5 to 24.9. So she was really unwell, really underweight, but very able to communicate her views, and she understood the information that was presented to her very well. She was, through cross-examination, she was clearly able to articulate that she was very aware that her calorie intake would lead to her death. And the expert, the psychiatrist in the case, explained that people with anorexia hold a false belief that they are not underweight, and it can be as intense as a completely fixed and unshakable delusion. It is not formally classified as a delusion, but the belief can be as intense. So that's really interesting because you don't necessarily have to have full delusional thinking to permeate your ability to use and weigh information. It can just be a really fixed view. And in this case, the judge held that she was unable to make decisions around her care and treatment, and stated that the evidence shows that there is no doubt at all that Beatrice cannot weigh the information relevant to a decision about the options for her care and treatment. The weighing process requires her to recognise that into the scales goes the stark fact that if she does not eat and hydrate normally, and very soon she will die, there is nothing to put on the side of the scales objectively in favour of starvation. Yet Beatrice cannot and does not undertake this weighing exercise because of the anorexia nervosa. So when is the decision to be made? Well, capacity is time and decision specific, And this is shown in the case of PC and NC and City of York Council 2013, in which case Judge Headley states that it is the capacity to take a specific decision or a decision of a specific nature with which the act is concerned. There will be cases where the attention is centred not only on a specific treatment or action, but on the specific circumstances prevailing at the time of the person whose decision-making capacity is in question. So in light of this, there's obviously lots of different areas of capacity that may need to be assessed. And with each area of capacity, you'll need to apply that capacity test, including those 4 limbs that we've just been through. So the relevant information for each area of decision-making will be different. And the MCA Code of Practice states that the relevant information includes the nature of the decision, the reason why the decision is needed, and the likely effects of deciding one way or another, or making no decision at all. So in the following slides, I won't go through them in great detail, but I've put some key areas of capacity decision-making and the leading cases around those areas of capacity. So capacity to make decisions in respect of legal proceedings. The leading case for this is Masterman, Lister and Brutton and Co. 2003. And the judge in this case stated that the test to be applied is whether the party to legal proceedings is capable of understanding the issues on which his consent or decision is likely to be necessary in the course of those proceedings. So it's quite a low bar comparative to other areas of decision making. In relation to assessing whether somebody has capacity to decide where they should live, the leading case for this is LBX and K and Ors 2013, in which Mrs. Justice Tice really helpfully set out a list of relevant information to consider when you're assessing somebody in that area. So examples would be what the 2 placement options are that they're choosing between, what sorts of areas the properties are in, and so forth. Also in that case, the judge set out some relevant information to assess somebody's capacity surrounding care. So this would include what sorts of areas of support they might need what sorts of areas they might need support with, what sort of support they might need, who will be providing them with support, and so on. Capacity to manage property and affairs. I've attached some links there to guidance that you might find helpful. We typically split the decision making into making smaller scale decisions and larger scale financial decisions. Capacity to engage in sexual relations. The test for this it was fairly recent that it did change. It was in 2021, and this was in the case of a local authority and JB. And in this case, they've added the limbs that P has to be able to appreciate that the other person that they are engaging in sexual relations with must have the capacity to consent to the sexual activity and must in fact consent before and throughout the sexual activity, because the offence of rape is a continuous act. So if you were engaging in sexual relations with somebody and it was consensual at the beginning and then midway through you asked them to stop, if they didn't, that would then become rape. So it's important that the vulnerable adult is also aware of that limb. So fluctuating capacity. This is another reason why capacity can get really complicated. So you could have somebody who has quite borderline capacity. So I've had cases where the protected party has had a really high IQ and it's brought into question whether they do actually have capacity in specific areas. Also, somebody might have the ability to mask their capacity. So they might very much give the appearance of having capacity, but actually they're hiding it. And fluctuating capacity is another one of these areas that's really quite complicated, and this is where somebody has capacity at one point and then lacks it at another. And the courts take two key approaches to this. So the first is called the longitudinal approach, found in the case of Cheshire West and PWK 2019. In this case, P at times became very overwhelmed with anxiety. And the court in this case drew a distinction between isolated decisions, and they gave the example of making a financial will, and decisions taken quite regularly. So managing your own affairs on an ongoing basis, and that could be done at very short notice. And the judge, Sir Mark Headley, commented that there will be times when a snapshot of his condition would reveal an ability to manage his affairs, but the general concept of managing affairs is an ongoing act, and therefore quite unlike the specific act of making a will. So the court took a longitudinal view on P's capacity, and P was deemed to lack capacity in many areas. A similar approach to this can be found in the case of Greenwich and CDM 2019, in which case Judge Newton considered whether the assessment of capacity to make decisions about diabetic management, or the matter in relation to which P is being assessed, is one macro decision which encompasses all of the many micro decisions that P is required to make when managing her diabetes, or whether P's capacity should be assessed in respect of each micro decision or group of micro decisions. And the two experts in the case, there was one independent psychologist, one independent psychiatrist, they both agreed that the management of P's diabetes had to be viewed at a macro level. And that was because the decisions very much interlinked and influenced each other. So P in this case did not understand that she was at risk of death when her insulin levels were very poorly controlled, and her emotional dysregulation as a result of her personality disorders was frequent and affected her ability to retain and to weigh information. And again, her capacity was viewed on a global basis, and the court held that she lacked capacity to make decisions in respect of her diabetes management. So the second approach is that of anticipatory declarations, found in the case of Wakefield, MDC and DN and MN 2019. In this case, DN had a severe form of autistic spectrum disorder and a general anxiety disorder. DN was assessed to generally have capacity, but when he had meltdowns, he became highly dysregulated and lost capacity. The judge observed that it seems to me that the outcome of an anticipatory declaration would provide a proper legal framework to the care team, ensuring that any temporary periods of deprivation of liberty are duly authorised. And so the judge made a court order to state that P had capacity except when presenting in a state of heightened arousal and anxiety, and at those times he was to be cared for in accordance with his care plan. And then the more recent case on fluctuating capacity is a local authority in PG and Ors 2023. And in considering these two key approaches, the judge in that case did not think that one was better than the other, but did clarify that how an individual P's capacity is analysed will turn on their presentation and how the loss of their capacity arises and manifests itself. So he's saying that either approach could be used depending on the circumstances of the case. But the court did say that regard was to be had to the importance of making orders that are workable. So what happens where there is a dispute over somebody's capacity? Well, in the case of a dispute, an application can be made to the Court of Protection to seek declarations on the issue of capacity. So in formulating declarations, the parties may well seek to obtain expert evidence through the course of those proceedings, and typically we would get those via an independent expert or what's called a Section 49 report, so through the trust. If the person's capacity is quite complex, then we would go for an independent expert. So that's to say somebody who is either a psychologist or consultant psychiatrist who also has the legal training to be able to pick up on lots of the nuances around capacity, because the case law is vast and capacity can be really, really complicated, and it can have really significant outcomes for the persons whose capacity you're assessing. If the case is less complex, then we might well ask a social worker to complete it through the local authority, or a treating consultant psychiatrist to complete the capacity assessment. So here's a case study example of one of mine, just showing what a capacity dispute looks like within the Court of Protection. They're quite rare. I've only had this case that's gone all the way to a full-blown contested hearing. And in this case, my client had a diagnosis of paranoid schizophrenia. He was from Ethiopia and came to the UK in 2005, had lived in various placements, at one point was very sadly homeless, and he ended up in a placement that was really restrictive. He'd been there for about 6 years by the time that we reached him. And the public authorities were looking at allowing to move him to various countries, despite his vulnerabilities, where his care needs would almost certainly not be met. So where they don't have free NHS healthcare, so Ethiopia, the States, and some other countries. And they considered that he did have the capacity to move abroad. The case was really complex because the 4 parties involved were disputing whether or not he had capacity, going back and forth with various bits of expert evidence. And so P's IMCA brought the case to us. We raised the matter with the Court of Protection, and proceedings were issued to obtain declarations primarily in respect of capacity, but also best interest and his deprivation of liberty. So after a number of court hearings and lengthy arguments, the court approved my client's move to a long-term supported living accommodation, which was less restrictive, so that was really good, and he really liked it there, and determined that actually he did lack capacity in the areas that we were saying he did lack capacity in. And the expert evidence in that case was really, really helpful, because what the expert was saying was that his delusions permeated his decision-making in that specific area, and therefore he couldn't have capacity in that area. So what is meant by best interest? Where you've got somebody who is assessed as lacking capacity in a specific area, then a decision may be made on their behalf, but it has to be done in their best interests. The term best interest is not actually defined by the MCA, but Section 4 of the Act provides a non-exhaustive checklist of matters which should be taken into account. For example, stating that the decision should not be made merely on the basis of a person's age or appearance or a condition of theirs, and the assessor must take the following steps, including considering whether it is likely that the person will regain capacity, and if so, when that will be. That they must, so far as they can, permit and encourage the person to participate, or improve their ability to participate. So you could have other assessments that help that. For example, assault assessment might be relevant there. They must also consider a person's past and present wishes and feelings. So before each court hearing, we'll go and visit the protected party. We'll go and chat to them about what they want, what they like, and we'll put that in a witness statement for the judge to read. And that's really important, because often in these cases you get care staff, family members with very strongly held views, very well intentioned, but it can sometimes supersede the views of the vulnerable adult. So the assessor must also consider the beliefs and values that the person may have, and any other factors that they would likely consider if they were able to do so. And where do the views of others come in? So when you're assessing best interests, who do you speak to? Well, under Section 4, subsection 7, the assessor must take into account and consult anybody named by the person as someone to be consulted, anyone engaged in caring for that person or interested in their welfare, any donee of lasting power of attorney, and any deputy appointed by the person by the court, for the person by the court. And in the case of Aintree University Hospital's NHS Foundation Trust and James and Orrs 2014, Baroness Hale noted that the purpose of the best interest test is to consider matters from the patient's point of view. So at paragraph 39 of this judgment, she helpfully stated that decision makers must look at his welfare in the widest sense, not just medical, but social and psychological. They must try to put themselves in the place of the individual patient. They must consult others who are looking after him or interested in his welfare, in particular for their view of what his attitude would be. So again, it's very person-centred. So here's another case study of mine. This is an example of a best interest dispute within the Court of Protection. And in this case, my client, she was relatively young at the time. She was in her early 50s. She had Huntington's disease, and capacity was not in question in this case. Everybody agreed that she lacked capacity in relation to her residence and care. What had happened was she'd moved to England from Scotland to live with her daughter. Then her health sadly deteriorated and she effectively ended up stuck in a care home in England. Her daughter then moved back to Scotland and really tried to get her mum to move back with her, and contacted the Huntington Society and made great efforts to get her moved, but wasn't able to. So as a result of that, my client was stuck living in a care home for 1.5 years. She was really, really clear that she wanted to live in Scotland, and eventually started to display acts of challenging behaviour. So she started to refuse to eat, she refused to shower, in protest at not being allowed to move back to Scotland. And the question for the courts and for the parties was whether it was in her best interests to move back to Scotland or not. The case was really complex because Scotland operates under a different legal jurisdiction. Their judges are called sheriffs, just a side note. And the issue of funding really wasn't straightforward because at the time there wasn't any guidance as to local authority to CCG funding where you've got cross-border cases. So in this case, we considered a number of pieces of evidence, including multiple witness statements, best interest analysis from social workers, a psychiatrist's report, and ultimately we had a number of hearings. I had many phone calls to the authorities in Scotland, and we managed to get her moved to a specialist placement in Scotland that was in a beautiful area with a scenic view, very close to her daughter, so she could nip and see her mum almost on a daily basis. And they were both delighted, so it was a really good outcome in that one. So, can a best interest decision always be made on behalf of an incapacitated adult? No. So under section 27, it states that you cannot consent to marry somebody on behalf of somebody else, or have a civil partnership, or consent to have sexual relations, or consent to have a decree of divorce. The Mental Capacity Act in practice. So where you've got a dispute and you've ended up in the Court of Protection, the Court of Protection is a specialised court. It was established by the MCA. It only has jurisdiction where a person lacks mental capacity. So if you have capacity, then you don't belong within the COP. It makes decisions on behalf of people who lack capacity in one or more areas. It can appoint deputies or resolve disputes in relation to lasting powers of attorney and or deputyships. And it can determine what is in somebody's best interests, including in relation to a deprivation of liberty, which I'll come on to talk about. The Court of Protection is primarily split, and that's into a health and welfare side and a property and affairs side. So my department within Owen Mitchell, the Public Law and Human Rights Department, deals with the health and welfare side of the Court of Protection. My colleagues in the COP finance team deal with the property and affairs side, so it is a different specialty, although sometimes you can have cases where finances are relevant to health and welfare, so paying for a placement, for example, and then they become kind of partially intertwined, but largely are kept separate. So who should make the application to the Court of Protection? Well, usually this should be the relevant statutory body, so that's to say the local authority responsible for the person's care, the NHS Trust, or ICB, so that's the Integrated Care Board, previously known as CCGs, clinical commissioning groups. If the public authorities refuse, or there's no known state involvement for that person, then other people can apply on behalf of that person or in their own right. So a financial deputy can apply, family members or others involved in P's care can apply, an IMCA can apply, and an application can also be made in P's own name with a litigation friend. So we frequently have applications in P's own name with a lit friend involved. And what can the Court of Protection actually do? So it can make decisions as to what's in somebody's best interests. And you'll note here that these areas are really, really important areas to somebody's life. It's quite invasive. The courts take it really seriously, but it's got very, very wide-ranging powers. It can terminate an LPA or deputyship order and even appoint new deputies. It can resolve capacity disputes like the one that I've described earlier, and it can make decisions very, very quickly and even out of hours. So I had a case last year that I thought was going to land on Christmas Day. Thankfully it didn't, but the courts were really good, and due to the urgency of the case, they actually heard the case within a day or so, and that was because my client had really severe health needs. So who represents the person who lacks capacity? So if the person lacks capacity, and they lack capacity specifically to be able to provide legal instructions for that specific type of legal case, then they will need what's called a litigation friend to act on their behalf and provide us with instructions. So that's to approve court orders or draft witness statements, etc. And the litigation friend must be able to act independently without putting forward their own arguments. And for this reason, sometimes, not in all cases, but sometimes family members are not deemed to be appropriate to act as litigation friends. But in many cases there are, and we've had family members act as litigation friends, and they've been great because they also have obviously a wealth of knowledge in respect of that person. So the following could also act as litigation friend. IMCAs, we often have IMCAs acting as lit friend. The official solicitor, this is a governmental office, and it's only to be used as a last resort. So that's to say where nobody else is willing or able to act in that role, then we'd invite the official solicitor to act as litigation friend. RPRs, relevant persons representatives, or ALR. And an ALR is a relatively new role. It's an accredited legal representative, and this is a solicitor, barrister, or chartered legal executive who's completed a special course, and effectively it enables them to both have conduct of the case for P and act as their litigation friend at the same time. So how is our work funded? Well, legal aid or public funding is available. Family members may qualify in their own right for legal aid. You can also have legal aid in P's name, or you could use private funds from P's estate if they don't qualify for legal aid. For what's called Section 21A cases, so where it involves a deprivation of liberty, where somebody is residing in a care home or a hospital, non-means tested legal aid is available. So in those types of cases, the legal aid agency doesn't look at how much money somebody has. They're looking primarily at the merits of the case and whether they meet that criteria. For Section 16 cases, so where somebody's living in, say, a supported living placement or in the community, those types of cases are means tested. So the solicitor in that case will need to see evidence of their financial means to see whether they qualify for legal aid. And at the end of the talk, I've attached a link to the legal aid eligibility key card, which breaks down that test for legal aid. But if you were to bring a case to a solicitor, they should be able to assess that, and they'll just tell you what information they need to see. So what is an IMCA? This is an independent statutory advocate for people who lack capacity, who have no one else to speak on their behalf or to be consulted. And when should somebody have an IMCA? This is when decisions are being made about serious medical treatment or significant changes of residence, for example, moving care homes or in and out of hospital. And what can the IMCA do? So they can do quite a lot. They can make representations about the person's wishes and feelings. They can view their health and social care records. They can act as a safeguard for their rights and raise any concerns. And they can bring an appeal or challenge the decision maker. So deprivation of liberty. The starting point for deprivation of liberty is Article 5 of the European Convention on Human Rights. And this states that everyone has the right to liberty and security of person. No one shall be deprived of his liberty, save for in cases where there's the lawful detention of persons of unsound mind. And it also states that everyone who's deprived of his liberty by arrest or detention shall be entitled to take proceedings by which the lawfulness of his detention shall be decided speedily by a court. So the leading case in relation to deprivation of liberties is the Cheshire West case of 2014. A colleague of ours in the Manchester office was involved in this case, and it really is a landmark case that changed the scope of these types of cases. It went all the way up to the Supreme Court, and the Supreme Court were asked to decide whether two adults with learning disabilities and an adult with cerebral palsy and Down syndrome were deprived of their liberty. They all lived in slightly different settings. They lived in a care home, a foster care home, and a supported living placement. And the Supreme Court confirmed that this was in fact a deprivation of their liberty. It also handed down what's now called the acid test. And this is to say, is the person under continuous supervision and control? So are they being continuously watched and supervised? And are they free to leave? So would they be stopped if they tried to leave, say, the care home? The person's compliance is not relevant to whether they are de facto deprived of their liberty. And it doesn't matter how nice the placement is. So in this case, Lady Hale said a gilded cage is still a cage. So you could live in a palace, but you could still be deprived of your liberty. So once you've established whether somebody is deprived of their liberty or not, applying that acid test, then you'll need to ensure that it is authorised, so it is lawful. The way to do it is to look at what type of placement they are in to start with. So if they're in a residential care home or a hospital setting, then the DOLs, the deprivation of liberty safeguards, will need to be applied. If they are living in their own home in the community or in a supported living placement, then their deprivation of liberty will need to be authorised via a court order. So there's no way of getting around it. There'll need to be an application made to court. So what are the deprivation of liberty safeguards? This is a procedure for authorising deprivation of liberties for people lacking capacity to consent in hospital or care home settings. It provides essential safeguards and protection for very, very vulnerable people. And the Mental Capacity Act Code of Practice states that the deprivation of a person's liberty is a very serious matter and should not happen unless absolutely necessary. That is why the safeguards have been created. And when do the DOLs apply? So the DOLs safeguards only apply if the person is deprived of their liberty in a hospital or a care home setting. The Ferreira case had a slightly different situation. In that case, Miss Ferreira sadly died while she was in intensive care. The Court of Appeal held that she was not deprived of her liberty because she was being treated for a physical illness and the same treatment would have been administered to a person who did not have her mental impairment. So she was not deemed in that case to be in a state detention, and therefore you don't need any authorisation, you don't need to apply the DOLS. And what's the actual process of the DOLS? So what does it look like? How does it happen? So a person is admitted to a care home or a hospital. The managing authority, which is the care home, requests an urgent or standard authorisation from the supervisory body, which is the local authority that the person comes under. The local authority will have their own internal DOLS team, and their DOLS team will carry out a number of assessments to assess whether the person fits the qualifying requirements. The best interest assessor has a duty to consult the managing authority and consider many different viewpoints of people involved in that person's care. And if the authorisation is granted, then it can be granted for up to a maximum period of 1 year. Equally, where you have a standard authorisation and you want to extend that, so say if it's in place for 3 months and you want to extend it more, it can be extended up to 12 months. So what are the qualifying requirements for a DOLS authorisation? This is that the person must be aged 18 or over, so that's the age requirement. The person must lack capacity to make their own decisions, that's the mental capacity requirement. They must be suffering from a mental disorder within the meaning of the Mental Health Act. The person must not require treatment under the Mental Health Act. There must not be a valid and effective advance decision refusing the treatment in question. And the proposed deprivation must be in their best interests and the least restrictive option available. So once the assessor recommends for the authorisation to be in place, then the supervisory body, i.e. the local authority, must issue an authorisation known as the standard authorisation. If you're looking for this in DOLS documents, it's the Form 5 form. They'll appoint a relevant person's representative, so if you're under a standard authorisation, you should definitely have a RPR. If there's no family member or friend who can act in this role, then a paid RPR must be appointed. And then you can add conditions to the authorisation, and I've given some examples there which can be really helpful because you can tweak it according to that person. So what rights do the deprivation of liberty safeguards give somebody? Why are they so important? So where somebody's under the DOLS, they'll have a representative. The person or representative has the right to challenge the person's deprivation of liberty through the Court of Protection. There is a mechanism for a deprivation of liberty to be reviewed. So it's aiming to avoid situations where you have somebody effectively stuck in a care home asking to leave. There are other avenues for them, or there might not be, but you don't want them to be effectively stuck there and not listened to and their views not heard. The care homes and hospitals must notify the CQC about an application to deprive a person of their liberty, so that's also important. So if a person is saying, so they're under a standard authorisation and they're in a care home setting or a hospital setting, and they're consistently expressing a wish to leave, it's very clear that they don't want to be there, then that will trigger a challenge to the DOLS authorisation. Legal aid for these types of challenges is available on a non-means tested basis, so they could have no money or lots of money and it won't be factored in. It will be assessed on a merits basis. And the type of proceedings that the Court of Protection would be looking at in relation to this are called Section 21A proceedings. So what's the process if somebody is not in a care home or a hospital setting, they're deprived of their liberty pursuant to the acid test, and they are in a supported living placement or they're in the community? Then this deprivation of liberty still does need to be authorised. They won't have a standard authorisation. Instead, an application to the Court of Protection will be required. The local authority should make this application and include capacity assessments and views of relevant individuals. It's typically just done on the papers, so the court will receive the application and won't require a hearing unless there is a dispute, there is a disagreement about what's best for that person or capacity, or it's quite complex. The judge will look at the application and say, actually, I want you all to come in. Legal aid is still available, although for these types of proceedings, they're otherwise called Section 16 proceedings, the legal aid agency will look at how much money somebody has and see if they qualify for legal aid. And that is that they have to come within £8,000 of assets. If they've got between £3,000 to £8,000, then anything in excess of £3,000 may be, the legal aid agency may ask for that amount in a contribution. And there are other tests, like they've got more than £100,000 of equity in a property, they may not be eligible, and so forth. But it can be assessed on an individual basis, having seen the relevant financial information. So, challenging a deprivation of liberty. This is another case study of mine, giving an example of challenging a deprivation of liberty in the court of protection arena. So, in this case, my client was 100 years old. He was a World War II veteran and attended court wearing a trilby. Everybody really liked him. The judge really sympathised with him. He was really highly intelligent, and he was very clear that he didn't want to live in a care home. He wanted to spend the last period of time that he had left in the home that he'd shared with his late wife. He was also really upset by sort of bad language used in care home settings. He just couldn't tolerate it, or any aggression from other residents. So his RPR visited him, brought the case to us. We brought the case to the Court of Protection. And the case was difficult because the commissioners of his care were refusing to pay for his package of care at home, despite the fact that actually it was cheaper than, once we'd looked at all the costings, it was cheaper than him being in a care home. And once we'd had lengthy hearings back and forth and we'd examined all of the evidence, the court did approve a trial return home for him, which was really nice, and a private package of care was sourced for him to provide him with 24-hour live-in care at home. So the Mental Health Act, I'm going to briefly talk about the Mental Health Act just to give an overview and a comparator to the Mental Capacity Act, so you can see the differences. And then once we come back from the break, I'll talk about the overlaps between the two statutory provisions. So when would you fall within the Mental Health Act? To fall within the Mental Health Act, you must have a mental disorder, which is defined under Section 1, subsection 2 of the Act, as any disorder or disability of the mind. Section 2A of the Act states that a person with learning disability shall not be considered to be suffering from a mental disorder or requiring treatment in hospital for a mental disorder unless that disability is associated with abnormally aggressive or seriously irresponsible conduct on his part. And Section 3 of the Act states that dependence on alcohol or drugs is not considered to be a disorder or disability of the mind, but of course you can have an impairment to the mind as a result of drugs or alcohol. So, for example, Korsakoff's, which would be potentially a mental disorder for the purposes of this Act. So, Section 2 of the Mental Health Act outlines the criteria for admission for assessment. And an application for admission for assessment may be made in respect of a patient on the grounds that they are suffering from a mental disorder of a nature, so that's the type or the pattern of illness, or degree, so that's the severity of the illness, which warrants the detention of the patient in a hospital for assessment for at least a limited period of time. And this must be done in the interests of his own health or safety, or with a view for the protection of others. The application must be founded on the written recommendations of 2 registered medical practitioners. So you'll frequently have 2 consultant psychiatrists and an AMP present. And the period of assessment must not exceed 28 days. So that's for a section 2. Because really the purpose is to just assess the patient and see what assistance they need during that time. Section 3 of the Mental Health Act outlines criteria for ongoing treatment in hospital. And again, the application may be made on the grounds that they're suffering from a mental disorder of a nature or degree, which makes it appropriate for them to have medical treatment in hospital, that it is necessary for the health of the patient or the protection of others. And again, it can be founded on the written recommendations of 2 registered medical practitioners. So it's worth noting there, I know that's a lot of statute and case law to get through, but there is a key difference there, that unlike the Mental Capacity Act, capacity and best interests are not actually central to the care under the Mental Health Act, but the focus is more so on the necessity test. So when can somebody be deprived of their liberty under the Mental Health Act? So in certain circumstances, the Mental Health Act can be used to lawfully detain somebody, for example, where they're resisting treatment or their detention. This is regardless of whether or not they lack capacity to decide to be admitted to hospital. So you can have many capacitous adults who are detained under the Mental Health Act in a hospital setting. They don't have to lack capacity to be under the Mental Health Act. The Mental Health Act powers can also be used in community settings, and I've set out some examples for you on that slide. So how do you challenge your detention under the Mental Health Act? So this is covered by section 66 to 89 of the Act. A patient may apply to appeal their detention under both sections 2 and 3 of the Act. Section 72 of the Act states that a mental health tribunal has the power to discharge a patient from a hospital and from a community treatment order under specific circumstances. Therefore, the powers and the scope of the Mental Health Act tribunal are not as wide-reaching as those of the Court of Protection under the MCA. So it's really worth knowing about the MCA and the Court of Protection, because it really is wide-ranging and can be really useful for patients. And what is an independent mental health advocate? So this is a specialist advocate. They are able to assist somebody who's been detained under the Mental Health Act. Schedule 130D of the Mental Health Act puts a duty on the responsible clinician to tell the person that help from an IMHA is available. They can help people to understand their rights under the Mental Health Act, any conditions or restrictions which may apply to them, their medical treatment, and the legal authority for their medical treatment. So I'll stop there. I think that's a good time to stop. It's a lot of law to get through, so I'm sorry, because law can be a bit dry sometimes. But I think we're going to go for a break, and then we will come back and I'll talk to you about the cohesion between the 2 acts. Thank you. So it's worth noting that we are seeing cases where a client has been detained under Section 2 or 3 of the Mental Health Act, and they've also been assessed as lacking capacity in certain areas. If they require assessment and/or mental health treatment, then the Mental Health Act will be more appropriate. The Dole's Code of Practice states that if the proposed authorisation relates to a deprivation of liberty in a hospital wholly or partly for the purpose of treatment of a mental disorder, then the relevant person will not be eligible if they object to being admitted to hospital and they meet the criteria for an application for admission under Section 2 or Section 3 of the Mental Health Act. So therefore the jurisdiction of the Court of Protection may end. So you might have a protected party within the Court of Protection and they need to be detained under the Mental Health Act. Typically that stops the jurisdiction of the Court of Protection, or it ends at that point, unless somebody's going in to hospital and they're being detained under the Mental Health Act for a known, definite or short period of time. Equally, you could have somebody who's under the Mental Health Act and you're starting to look at discharging them from hospital, and it may evoke the jurisdiction of the Court of Protection. So there may well be jurisdiction to issue in the Court of Protection. And we've had cases where the hospital effectively has had somebody where they're quite complex. There might be interlinking immigration law issues. They may be effectively bed blocking because they can't find them the right placement. And in those cases, they've been quite grateful that we brought the application to the Court of Protection to resolve everything. So the MCA and the Mental Health Act may be applied at the same time in a hospital setting. An example of this is where an individual detained under the Mental Health Act is assessed as lacking capacity to consent to physical treatment, and this treatment is also deemed to be in their best interest to receive. So if a patient only has a physical health issue in hospital, then any deprivation of their liberty should be under the Mental Capacity Act. The Mental Health Act Code of Practice states that the need for physical treatment is the only reason. If the need for physical treatment is the only reason why the person needs to be detained in hospital, then the patient is not within the scope of the Mental Health Act. However, the Mental Capacity Act and the Mental Health Act may also be applied at the same time in the community. An example of this is where you have an individual who is under a CTO, a community treatment order, to assist them to be compliant with their medications, and they may also fall under the dole system pursuant to the MCA because they are assessed as lacking capacity to decide where they should live and receive care. So we have a case at the moment where the client has been under the health system for about 17 years, has gone in and out of hospital, and her capacity was never really considered. So she was in a private flat, and she was unable to manage her tenancy agreement, manage her finances, manage her medications, etc. And in that case, it's the first time where the clinicians in the case and the lawyers involved were all working together so that she comes out of hospital under a CTO and will also be under the dole system. So just to set her up with the best possible chances of staying out of hospital and having the best quality of life. So there are other Mental Health Act powers that may be used in the community. Again, I've listed those there. But it's worth noting that the Mental Health Act powers do not authorise a person's deprivation of liberty in the community. So the case law on that is really clear. So there can be overlaps between the two provisions, like I've just set out, CTOs and doles, which are under two separate pieces of legislation. But the Supreme Court held in the case of the Secretary of State for Justice and MM 2018 that the Mental Health Act does not permit the mental health tribunals to order a conditional discharge of a restricted patient subject to the conditions which amount to a deprivation of their liberty. The responsible clinician has a power to provide for a lesser restriction of movement than detention in hospital, which may nevertheless be an objective deprivation of liberty provided it is used for the specific purposes set out in the CTO scheme. So you can see there that the Code of Practice for the Mental Health Act does provide a little bit of a exemption or specific circumstances where that it's a bit of a grey area on that, but other than that it's very clear that the Mental Health Act should not be used to deprive somebody of their liberty in the community. So often in these cases what we see is where there's been poor planning around the client being discharged from hospital, or where there's been a lack of cohesion between health and community care, those are the cases where the client is much more likely to be admitted again to hospital, and they also have ongoing complications with their capacity and best interest. So it's really important to get the discharge from hospital stage right. In these types of cases, it might be appropriate to bring an application within the Court of Protection for declarations to resolve any disputes around their capacity, best interest and deprivation of liberty. So this is a really recent case, just highlighting the cohesion between the two acts. And it was Manchester University Hospital NHS Foundation Trust and JS and Manchester City Council 2023. And in this case, the hospital were saying that Jane didn't meet the criteria to be detained under Section 3 of the Mental Health Act. But she did need to be in hospital, and therefore the hospital invited the court to authorise her deprivation of liberty using the MCA. And the judge declined to do this. And he said that, firstly, she was accommodated at the hospital as a place of safety because there was nowhere else for her to go. And once the physical damage caused by her overdose was successfully treated, she needed no inpatient medical treatment. The answer to that is, of course she did. She needed to be nursed safely and medicated to address the effects of her mental disorder. It was submitted by the hospital that although Jane suffers from a mental disorder, it is not of a nature or degree, so that's going back to the assessment criteria, to make it appropriate for her to receive medical treatment for that disorder in a hospital. This is clearly wrong. It was necessary to keep her safe and prevent her from absconding or harming herself. It is submitted that the outcome of the Mental Health Act assessments was that inpatient care for Jane's condition was neither available nor desirable because she could be treated in the community under the Mental Capacity Act. This too is plainly wrong. She could only be treated in the community once a suitable package of care was available for her. Until then, she could not safely leave hospital. This is quite a familiar situation for those who practice mental health law. Patients who have been detained under the Mental Health Act can theoretically be discharged into the community with a suitable package of care, but only when that package is actually available. The whole Section 117 process is designed to speed that up so as to ensure detained patients get out and stay out of hospital. Of course, because Jane was never detained under Section 3 of the Mental Health Act, Section 117 aftercare was not available to her. So for Section 3 admission, obviously that needs to be a clinical decision. If somebody meets the criteria, they meet the criteria. It shouldn't be that they are not put on a Section 3 so that they avoid having to pay for the Section 117 aftercare. They either meet the criteria or they don't. The hospital thought that utilising the Mental Health Act to detain Jane would be harmful to her mental health, as would her remaining in hospital. This is an invalid argument which contains two fallacies. First, she was detained by her care plan, which I have summarised above. What jurisdictional label is placed on the care plan is immaterial to its restrictive nature. Secondly, keeping her in hospital for a day longer than was necessary was also nothing to do with the regime that she was subject to. Good clinical practice and the operation of Article 5 of the European Convention requires a patient to be detained for only so long as is necessary. The Mental Health Act does not prolong detention. In fact, as I've already said, proper use of the Section 117 should reduce the overall time a patient spends in hospital, because professionals inside and out of hospital concerned with the health and social care should all work together to put together an effective discharge plan speedily. There seems to be a belief, not just in this case but in others, which I have heard recently, that the decision to use the Mental Health Act should be viewed in isolation from what is available elsewhere at the time the decision to detain or not to detain is taken. if the patient has to be detained for treatment for their mental disorder and there is no alternative outside the hospital setting and no other treatment plan available, then it seems clear to me that the patient should not be detained under the Mental Capacity Act, but under the Mental Health Act. So I think often there can be confusion between the two statutory provisions, or not much is known about the Mental Capacity Act. And so that can lead to a lack of cohesion between health and community care. But hopefully by providing this information, it can slightly bridge that gap. So to summarise, the Mental Health Act and the Mental Capacity Act may both apply to a non-compliant incapacitated adult, but only the Mental Health Act would apply to a non-compliant capacitous adult. The purpose of the Mental Health Act is to help patients give patients compulsory care in a hospital, but the Mental Capacity Act is to support adults with all areas of decision making. The Mental Health Act applies a necessity test, whereas the Mental Capacity Act applies a best interest test. So I'm going to give a brief, sorry to introduce another statutory provision, but I'm going to give a brief overview to the Care Act. And the purpose of this is so that we can take a step back and see how the statutory provisions interlink and how they can best be utilised to help patients. So the Care Act, the key principles of the Care Act I've set out for you there, and these are the general responsibilities of local authorities. So if you're working within a hospital setting or a local authority setting, it's worth noting what the local authority should be doing. So under Section 1 of the Act, there is the wellbeing principle. Section 2 outlines that the local authority has a general responsibility to prevent needs for care and support from developing. Section 3, they're to promote the integration of care and support with the health services, so they should be working with the health services. Section 4, they should provide information and advice. Section 5, they should provide diversity and quality of services. So when do local authorities have safeguarding duties towards an individual? So say if you have somebody who's on a ward or hospital setting, when would the local authority have a responsibility for them? So safeguarding duties apply to an adult who has needs for care and support, is experiencing or at risk of abuse or neglect, and as a result of those care and support needs is unable to protect themselves from either the risk of or the experience of abuse or neglect. And how can an advocate support an individual with care needs? So I've put the relevant regulations at the top there, should you ever need to refer to them. But an advocate can make representations on behalf of somebody who isn't able to, in order to secure their rights. Where the advocate has concerns about how a local authority has acted or a decision that they might have made, they must write a report outlining those concerns. The local authority must take into account the advocate's representations, have a meeting with them, and then provide a written response. Where the individual doesn't have capacity or is not able to challenge any decision made, the advocate must challenge any assessment or planning decision where they believe that it's inconsistent with the local authority's duty to promote the individual's well-being. And what is the eligibility criteria for care and support? So this looks at what outcomes the person isn't able to achieve as a way of defining whether or not they have eligible care needs. The Care and Support Eligibility Criteria Regulations 2015 sets out that the needs must arise from or be related to a physical or mental impairment or illness, and as a result of the needs, the adult must be unable to achieve 2 or more of the specified outcomes, which we'll come to. And as a consequence of the above, there is or is likely to be a significant impact on the adult's well-being. So those 3 points I'll break up for you now. So in relation to the first one, arising from or related to a mental and physical impairment, The local authority must be satisfied that it's not caused by other circumstantial factors. No formal diagnosis is required. So I've had a local authority say that to me once, that a formal diagnosis was required, and that's incorrect. It can include any mental disorder. It appears to include substance or alcohol misuse. And it's worth noting that the wording used there, which is all related to, is much broader than directly caused by. So it does include needs indirectly caused by an impairment. And in relation to the specified outcomes, the person only has to be unable to meet 2 of these. So that's really not that much for them to be able to qualify as having eligible care needs. There's a long list there. And how do you assess whether they are unable to meet 2 or more of the specified outcomes? Unable is set out in the statutory guidance, and this means unable to achieve the outcomes without assistance, whether they're able to achieve it without assistance, but in doing so causes the adult significant pain, distress, or anxiety, where they are able to achieve it without assistance, but doing so endangers or is likely to endanger the health of the adult and others, and is able to achieve it without assistance, but in doing so takes significantly longer than it would otherwise take. And it's worth noting that there's no hierarchy of needs either for the local authority's purpose. And how do you assess whether this is having a significant impact on an individual's well-being? What does that mean? Well, significant is not actually defined in the Act, so it's just given the everyday meaning. But you can apply this against the relevant Section 1, subsection 3 factors, which we've already been through. And the statutory guidance states that in making this judgment, local authorities should look to understand the adult's needs in the context of what is important to him or her. So not what's important to the assessor, but what's important to the person that's being assessed. And then the process. So how do you get a Care Act assessment and funding to support that person with their care needs from the local authority? The first step is to request a needs assessment from the local authority. It may be best to do that in writing. The second step, the local authority will confirm whether or not it will carry out an assessment. If they refuse, then that may well lead to a separate legal challenge, which is called a public law challenge or a judicial review. So that's something that a solicitor would be able to assist you with. That's one of my specialties, in addition to COP cases, and many other firms do those types of cases as well. The next stage is the assessment stage. So the local authority must assess the individual in an appropriate and reasonable timescale, and each identified need will be assessed against national eligibility criteria. If there are significant delays to the assessment being produced, then for obvious reasons, because in that time the person has care needs that are not being met, again that can lead to a public law challenge in of itself. But typically for those types of cases, we'll write a letter to the local authority highlighting the law, and then they'll note it and they'll undertake the assessment. The next stage is meeting needs. So they'll start the care and support planning stage, and they'll set out how the eligible needs will be met. If at that stage you think actually a lot of the needs have been minimised or missed out, then by all means flag that to the local authority to ensure that all the care needs are being properly met. If they refuse or there's a dispute, again, it can lead to a public law challenge. So the next stage is the financial assessment stage. The local authority can assess and decide whether a financial contribution will be requested. And then finally, care will be provided directly or via direct payments. So they'll be given the money and then they can choose to spend it themselves on the care. And will the client be charged for care? So there is some discretion to the local authority to make a charge for meeting needs. Some care is free, and I've set out some examples for you there, including Section 117 aftercare. But it really does depend on the case for the individual client. Carers. So carers are entitled to a separate type of assessment. This is a carers assessment. Try not to get them mixed up, because sometimes local authorities may come back and say they've done a character assessment, and it's worth noting that a carers assessment is a separate assessment entirely. So if you've got carers, so family members who are looking after somebody, you want a character assessment and a carers assessment, so two separate assessments. So what responsibilities do local authorities have towards carers? The eligibility criteria for carers asks whether, as a consequence of providing care, the carer is unable to undertake certain key roles or tasks, or whether their health is at significant risk. So obviously, if you've got carers providing care, you want to support them either through respite or other care staff members, depending on how many hours of care that they're willing to provide, or pay them for the work that they're doing as a carer. Otherwise, you may well have a situation where the carers themselves develop care needs, which then have to be met by the local authority. So it's counterintuitive, because you're incurring further expense and care needs from developing. Or you may have a really dangerous situation where the entire care package breaks down. So it's really important that the carers have a carers assessment and the person themselves have a Care Act assessment. The Section 20 duty under the Care Act to meet the carer's needs for support. It does this by providing support to the carer or care to the adult being cared for by the carer. The carer must also be providing necessary care to the adult. And there are also specific sections that deal with adults who are caring for children and young carers who are transitioning into adulthood. And I've set those provisions for you there. So where you've got a patient and you're looking to discharge them from hospital, again, it's worth noting that in conjunction with the Mental Health Act, as you may want to consider the Mental Capacity Act, you may also want to consider the Care Act. And this may well be engaged where a patient has identified care needs. Section 91 of the Health and Care Act revokes the requirement in Schedule 3 of the Care Act, which required local authorities to carry out long-term health and care needs assessments before discharge from hospital. And this is replaced by a duty on NHS trusts to involve patients and carers in discharge planning. So I've put a checklist here that may be useful. So where you've got somebody and you're looking to discharge them from hospital, to give them the best possible chances of success in the community, you might want to run down this checklist and check that you've got everything here. So to consider whether a patient is assessed as lacking capacity to make decisions in certain domains, and so falls under the Mental Capacity Act or the DOLE system, which we've been through today, whether a patient has physical care needs that need to be met by the local authority, and so fall within the Care Act that we've been through today, whether the patient has been detained under Section 3 of the Mental Health Act and so is entitled to Section 117 aftercare, and or which statutory body should be responsible for funding their care. So that's quite important, because sometimes you can have a patient who's ready for discharge, they're effectively bed blocking, it's not in their best interest to stay on a hospital ward, but you can get statutory bodies sort of arguing about who should pay for that person's care, and that can hold up their care. So it's worth just clarifying who's going to pay for that person. And then whether a patient's care package in the community would involve family members, and if so, whether a Care Act assessment is required under the Care Act. So this brings us on to the potential different legal avenues that you might want to run through for clients. So you could potentially have a case where you have a client with a multitude of different issues, and it can be quite difficult to know which legal avenue to go down. So you might have somebody with dementia, they might have eligible care needs under the Care Act, but the best way to resolve any issues or disputes about their care might be through the Court of Protection. Equally, you could have somebody who's homeless and struggling to obtain adequate housing provision. They may have eligible care needs and so fall within the Care Act, and the Care Act route might be the best route to go down rather than trying to use housing law provisions. A person whose immigration status means that they have no recourse to public funds could have eligible care needs. You could have somebody detained under the Mental Health Act and they're ready for discharge, and they might also have capacity issues. It may be that the best way to resolve any issues or disputes about their community care might be through the Court of Protection. Equally, you could have somebody who's under the doles in the community. They have a deterioration in mental health, and the only way to help them is to help them by a hospital detention under the Mental Health Act. So here's a case study of mine demonstrating a client who had a multitude of issues. She fell under different pieces of legislation, but her case was resolved through the Court of Protection. And in this case, she had a diagnosis of paranoid schizophrenia. She was assessed as lacking capacity to make decisions in respect of her residence and care. Her care needs were steadily increasing, but she had an outdated care needs assessment, so that would have been under the Care Act. She wasn't under the deprivation of liberty safeguards because she was free to leave, but she effectively loved her flat and never wanted to leave her flat. But in view of the concerns about her increasing care needs, the local authority very understandably brought an application to the Court of Protection to move her from her privately rented flat to a care home. My client really wanted to stay in her flat. She'd lived there for many years, and so the parties considered whether it was premature to put her into a care home or not. Many pieces of evidence were filed, including an updated care and support plan. And ultimately, the parties agreed in that case that it was premature to move her into a care home, but noted that in the future, because of her increasing care needs, it was likely to need to happen. But it would have been far too restrictive to move her into a care home if she didn't need to be in a care home. And obviously, if you move somebody into a care home, their care needs can increase because they can effectively become institutionalised. So it's quite difficult to then move them back. So it's a decision that shouldn't be taken lightly. So what about clients who may not fall under those statutory provisions but may still require support? So you might have cases where they have legal provisions that are specific to their cases. For example, a family fleeing domestic violence or victims of modern slavery or human trafficking. So this is the last case study of mine. My client was a victim of modern slavery. He was a Polish national and he'd been exploited for labour, his benefits and financial fraud by traffickers in the UK. He did appear very vulnerable. So when I spoke to him, although there was a language barrier, it was clear that he may well have mental health issues and or capacity issues. He was assisted to leave his exploitative situation by an outreach worker from a homeless charity. And they were really, really good at their job and very specialised. So they managed to help him in that situation. He was also then assisted by an organisation aiming to end human trafficking and modern slavery. And they were also really good because they had a social worker and a lawyer that teamed up who specialised in this specific area. We were referred this case from the latter organisation and worked really closely with them throughout the case. And what we did was, my challenge was to the Home Office denying him support, saying that he didn't meet the criteria for being a victim of modern slavery, even though he clearly did. The outcome was that the Home Office conceded and confirmed that there were reasonable grounds to believe that this was a case of modern slavery. And so he was entitled to the specific support from the government that he really needed. And that can include housing, medical care, legal advice, an interpreter, and even police, because often in those types of cases, the perpetrator of the crime will try to get the victim to come back into the exploitative situation. And you can see there that the relevant law that I ended up using was not the Care Act or the Mental Capacity Act, but these specific pieces of law, which was more helpful in this case. So, to summarise, the Mental Capacity Act is a really, really important, huge piece of legislation. There are hundreds of cases that surround the Mental Capacity Act. It can really help clinicians provide a really comprehensive, holistic approach to a patient's care. The Mental Health Act is more limited. Both of the provisions can be used in community settings and hospital settings where appropriate, and in some cases they can be used in conjunction with each other, as I've set out in these slides. The Care Act is also really important. It can overlap with these provisions where somebody has an identified physical care needs. If there's a dispute about any of this, then you may want to approach a solicitor and they'll help you decide which avenue is best to go down. I've attached some links for some useful resources that you might want to have a look at later. And I've also attached my email address. So I think I don't want to run into Janice's time, but I think we've reached my time limit. Yeah. So if you've got any questions, just send me an email. I'm more than happy to answer any questions that you might have now or in the future about patients via email. So thank you very much for listening.
So the aims of my part of the talk today are to increase awareness of best practice around assessment and documentation, think about factors to consider when assessing capacity, think about executive capacity. Some of you might have heard that term before. What's that mean and how do you assess that? And techniques to enhance capacity as well. So there's lots of different questions we can be asked to assess regarding mental capacity. Some of these are one-off decisions and some are ongoing decisions, which Elizabeth was talking about the difference between the two earlier. So examples of ongoing decisions are things like admission for care and treatment, care needs on discharge, and managing finances, because every time a carer comes to the door, somebody has to decide whether to let that person in or not. Every time somebody wants to spend money, they're having to make a decision. So we are not going to be in there assessing their capacity every time they're making one of those decisions. So it's a bit different from just a one-off decision, like making a will or deciding on a medical treatment. So these require the person to be able to retain the information over a longer period of time, not just over the assessment period. So repeat assessments are very helpful here. You come back another time to see if the person's retained the information over that period. So can they use the information in the next week or month? So it's usually a good idea to do more than one assessment anyway, unless it's very obvious in the first assessment that the person does or doesn't have capacity. And we had someone, I used to work on the INRU, we had someone on the ward who we went along, did a capacity assessment about discharge, destination, and by the end of the session we're thinking, I'm not sure he does have capacity for this. And we went back the next day, and just because his information processing was so slow, it had taken him that time to think about all of the relevant information and to process it. And when we went back for the second assessment session, he was able to give really good answers. So actually, he did have capacity to make that decision. If you're thinking about someone being admitted to hospital and thinking about putting them under a DOLS, they need to be able to retain the information about their care and treatment over the whole hospital admission. So again, on the INRU, what we used to see is people coming in saying, yes, I know I need treatment, I need to be here. And then something would happen, usually around Christmas Eve. They would say, oh, I want to go home for Christmas. And suddenly everybody's like, oh no, you can't leave the ward, but you're not on a dolls. And then suddenly we're called in to do a quick dolls assessment. There are specific difficulties assessing people with acquired brain injury. They can have quite subtle cognitive problems that aren't obvious in everyday conversation, but they can affect the complex decision making if someone's in a community setting. People can have problems with insight into their difficulties, and that's from their acquired brain injury, so that's different from denial. Denial is more of a psychological defence mechanism where somebody is not able to accept what's happening to them, and so they sort of, their brain sort of can't process that. So they don't believe the information actually relates to them. And this is a really important point as well. When I predate the MCA, and in the common law, there used to be something that said the person has to believe the information. When the MCA came in, it didn't have that. And so when I went to the training, I sort of said, where does the believing come into it? And the trainer said, well, it comes into understanding. Because if you don't understand the relevant information applies to you and believe it applies to you, you're not actually understanding that situation properly. Often people can repeat back information without having a full understanding of it, or they have a partial understanding of it, or they might have misunderstood it but can say it. And I have done capacity assessments where somebody has been able to tell me all the information, and I said, do you believe that you're going to have a fall? Or do you believe that this applies to you? And they're like, oh no, I'll be fine. But if I hadn't asked that question, I would have thought they had capacity. There's also something called the frontal lobe paradox, which the term dates back to the 80s, and we've sort of moved on from that now because we know that executive functioning is not just in the frontal lobes. But this was the term used by George and Gilbert in a paper they wrote in 2018 about people who can talk the talk but not walk the walk. So they can say all the right things, but they can't put it into practice. And I'm sure you've all met people like that. And that was sort of, although we've been looking at that for many years, that paper was the start of the process. It went to Parliament, and social care took it on board, and now they bring that into social workers training, which is great. And also the structure of a formal capacity assessment can actually hide some of the difficulties that somebody has. If we think about someone with executive functioning problems, we are sitting there structuring the information for them, so actually that can hide some of those difficulties. And we need to remember that not all disabilities are visible. So, as Elizabeth said as well earlier, people's capacity can change over time, it can fluctuate. Sometimes the people we work with, we are going to see improvements in capacity, for example, if they've had a traumatic brain injury or a stroke, but also sometimes we might see declines in people's capacity over time if someone has dementia, for example, or MS. Sometimes it can fluctuate within the same day or same week. For example, people with dementia sometimes show something called sundowning, where at the end of the day their cognition starts to tail off. Or somebody with Lewy bodies might have fluctuations even within the same day, it might go up and down. Someone might have delirium due to an infection or another medical condition. Intoxication from drugs and alcohol would obviously affect capacity. And medication can improve or reduce capacity. Sometimes if, for example, someone with Parkinson's has just taken their medication, they feel a bit brighter, they're able to focus better, they can process that information better. But someone else might be taking medication that's actually got a sedative effect, so that they're not able to process information as well. So you just need to take that into account when you're thinking, when's the best time to do your assessment? Or if someone's got a psychiatric condition and they're not taking their medication, then that might affect their cognition, the cognition which affects their capacity. And something like severe pain or fatigue as well can affect people's capacity. I've got a little case study here. So this is one that Kate Wilkinson did, a lady that was on the INRU many years ago. Maud's not her real name. She was 56 at the time, and she'd had undiagnosed pneumonia, which led to respiratory arrest and then cardiac arrest. And unfortunately, she had a hypoxic brain injury. So when Kate saw her, it was 5 months after this. And she had difficulties with mobility and care tasks. When we did a cognitive assessment with her, we found that she had problems with memory, attention, aspects of executive functioning, and speed of information processing. She also had a lot of anxiety, which was long-standing. However, the brain injury had made it more difficult for her to regulate her emotions. So Maud was usually happy to stay on the ward and engage in rehab, and she said she wanted to get better. However, there were occasions when she said, no, I just want to go home. And the MDT were like, oh, no, it's a bit risky. We've not got anything in place. And this was usually when she was panicking. And the trigger was often breathing difficulties. So it just so happened that the two capacity assessments that took place, one was on what Maud called a good day, and one was on what she called a bad day. During the capacity assessment on the good day, it was found that she actually did have capacity to make a decision about care on discharge, when she was supported to think around the options. However, on her bad day, she was unable to use and weigh that information. So it was a temporary loss of capacity. However, as Elizabeth was saying earlier, with that fluctuating capacity, overall, more often than not, she had capacity to make that decision. So we stated that she did have capacity to make the decision, but we worked with her to create a care plan, and she agreed that an emergency DAWS could be put into place when she lost capacity, if the MDT weren't able to persuade her to stay, so if she was having one of her bad days. So it's often when things go wrong or somebody refuses something that we think that they should have, that people go, oh, maybe they don't have capacity. And we should actually be thinking about someone's capacity even if they're agreeing. For example, if they're agreeing to stay in hospital, we still need to think about their capacity, because we might be depriving them of their liberty without realising. So we do have to have that presumption of capacity, and usually we would have supported conversations around topics, and that might be at that stage we might start thinking, I'm not sure this person's actually understanding or retaining or using and weighing that information. We might then have an impression of capacity, but as I'll come on to later, impressions of capacity don't really stand up to formal assessments of capacity. And there are certain decisions where it tips over into needing a formal assessment capacity anyway, if it's a serious consequence for that person. So we don't just go into a session and talk to someone and ask them what they think about the situation. We try and think of it as a holistic assessment, just like most of your other assessments. You're not just going to look at one thing, you're going to look around that as well. So we might take information from cognitive assessments that have been done. We might make observations on how they're functioning, how they're coping with tasks. We might interview family and friends, get information from the MDT. And these have all been recommended to supplement that capacity assessment. So all of this research is a bit old, but nothing's really been done more recently, so I still quote it because I still come up against these issues even now. So the idea that just going along and having a chat and making an assessment that way is gold standard, has been discredited when it's compared against a formal capacity assessment which has a structure and you're basing it on the MCA. So little agreement was found between clinicians' opinions, and they often use different standards, some of which fall under a diagnostic approach, which means just thinking about what that person's diagnosis is and saying. And in the olden days, this is why something like the MCA came about, was that, for example, if someone had a learning disability, people would be questioning that person's capacity to make decisions far more than someone who didn't have a learning disability. So that's a diagnostic approach. And then the outcome approach is someone's making a risky decision, we have to do a capacity assessment, rather than actually thinking, is this in their person's best interest, even if it's not risky? For example, a medical treatment that we're suggesting. So when the study was repeated later on, they'd given specific legal standards to the clinicians. They found that actually the physician agreement increased to 76%, which is fairly decent. And probably actually, if they had then got the physicians together to discuss the assessments and what they'd done, you'd probably find the agreement increased further. So it's been concluded that knowledge about patients' capacity to refuse treatment is generally quite low, and I know that's a really old study. However, we still come across it with our medical colleagues. They don't get a lot of training in mental capacity. So, thinking about MDT, clinical teams and families, again, impressions of capacity aren't always correct, and it's usually when the person doesn't have capacity. So there's often a group of people who clearly don't have capacity, and there's a group of people who clearly do, and then there's that grey area in the middle, and they're the tricky ones. But people will err on the side of thinking, oh, yeah, they've got capacity, rather than sort of doing a formal assessment. And that fitted with the research I did as well. The MDT found it more difficult to identify people without capacity to make a decision about discharge destination than those who did have capacity. So who should be assessing capacity? Often as a psychologist, people come to me and say, can you assess this person's capacity? And I'm saying, can you not do it? One, because I'm very busy, but also actually the whole team should really be assessing capacity. And in the INRU, that was a real strength of the team. Everybody felt that they could go in and do capacity assessments, and often the psychologists weren't involved unless it's quite a complex case. So for everyday decisions, the person caring for the person may just do an informal capacity assessment, so they might just ask a few questions. You're not going to sit down and do a structured assessment on what someone wants to wear that day or whether they want to have a bath or a shower. If a healthcare professional is proposing treatment, they're the decision maker because they're the ones who's going to be carrying out that decision. However, they may ask the MDT for support around that capacity assessment because they might not feel that they're able to do that capacity assessment. Quite a few years ago in Trafford General, we had a safeguarding matron who was excellent on mental capacity. She said she was happy to go on any ward in Trafford General and assess mental capacity, but when she came to the INRU, she always wanted one of the psychologists with her because she was aware of that difficulty with people with ABI and assessing capacity. It's just that bit trickier. So she felt more secure with one of us with her. Again, legal aspects require a solicitor, so the solicitor is going to be the decision maker. However, again, often we used to get asked to support that assessment because they didn't feel able to do an assessment of someone with a brain injury or a neurological condition. And then more complex decisions, such as those involving high levels of risk, require a formal assessment, and that could be by anybody who's an expert in capacity, but it's still to advise the decision maker. And the decision maker is the one who will then be the ultimate person who decides whether that person has capacity or not. And you might need a second opinion if there are disagreements between people who have assessed capacity, or if the family are saying, no, I think they do have capacity, and are disagreeing with the assessment. So we would often go to second opinion before we would go to the Court of Protection. We'd try and do it that way first. So there are lots of different levels of skill and expertise in teams. Some decisions are more relevant for certain professions to do the assessment. For example, if it's a swallowing assessment, it would obviously be speech and language therapy. If it's around care needs on discharge, the OTs are great for doing those. If it's a medical procedure or admission for care and treatment, it might be the medics. I know nursing staff do some of the care and treatment assessments as well. And in an ideal world, the assessment would be carried out jointly with an expert in the field and an expert in mental capacity. And then again, getting your speech and language therapist colleagues involved if the person does have communication problems. And it's useful to get those experts involved from the start rather than doing a capacity assessment and then going to the person and saying, oh, I've done this, what does that mean? So when do you seek a more expert opinion? If assessors can't form a reasonable belief of lack of capacity following reasonable steps to determine this. Some complex or major decisions with serious consequences, you would want someone who's more expert in mental capacity. Someone challenging a decision made by assessors, disagreements, as I said. If the person's saying different things to different people, that's quite an interesting one, because you have to try and work out, well, why are they doing that? Is it that they've got fluctuating capacity? Is it that they're just saying what they think you want to hear? Or is it that they're not remembering and they're just saying something different? Conflicts of interest, any sort of abuse of a vulnerable adult, or risk of serious harm, again, you'd obviously want an expert to come in. I'm just looking at the time, Cillian. What time was the next break? Because that's a decent place to stop if you want to stop now. Okay. So just starting to think about which cognitive functions link into which aspects of the mental capacity test. So people need to understand the decision and why they need to make it. So we'll be thinking about language, insight and orientation there. Understanding information relevant to the decision also brings in attention, memory, and starting to see executive functioning come in there. Retaining the information, obviously memory, and then using and weighing the information to make the decision. Also thinking about aspects of executive functioning like inhibition. So if somebody is able to say, oh yeah, I won't have a drink when I go to the pub, but then they go to the pub and they can't stop themselves from having a drink, then they're not able to use the information in the situation. And then communicating their decision, which can be non-verbal. And we also need to remember that someone may lack the capacity to make one decision, but then have the capacity to make even a very similar decision. I had a question about decision makers in the break there. So decision makers, so the situation was somebody who needs a peg because they're not eating. So the decision to refer the person for a peg would be the consultant's decision. They'd be the decision maker because it's part of the person's care. However, the surgeon who is inserting the peg would also need to do their own capacity assessment around the actual surgery, because obviously there's risks around that. I can't remember if I come on to this, but depending on who is paying for care, for example, if social services are paying for care, they're the decision maker. If continuing healthcare are paying for the care, then they would be the decision maker. Sometimes you can have an MDT as the decision maker. It doesn't always have to be one person. In certain situations, that might be the case. For example, ongoing therapy or time for discharge, that sort of thing. Okay. So cognitive assessments aren't always necessary when you're doing cognitive capacity assessments, but they can, as we said earlier, be useful for giving that more holistic view. They can help you think what sort of level of functioning the person's at with their language or their memory, and you can change the capacity assessment to enhance that person's capacity. Sometimes it's useful in those borderline cases when you're not really sure if someone's understanding something or able to do something. You might get some information from a cognitive assessment which helps your the way you change the capacity assessment. Something like the mini mental state examination, which isn't really used much anymore, they've had really varying results when relating that to capacity assessments, but it doesn't really look at executive functioning. So if someone does have cognitive difficulties, look out for consistencies in responses. Watch out for suggestibility or acquiescence, so somebody that just says yes to everything that you suggest, and try and reduce the likelihood. So you can reduce likelihood by asking open questions rather than questions that are closed and need just a yes-no answer. Taking a neutral stance yourself, so not being swayed and holding back your own personal opinions of what might be best for that person. Don't use leading questions. So one case I was involved in quite a long time ago now, somebody had gone in, so this was someone that did go to the course of protection, and she'd had about 3 different capacity assessments. We'd had an independent second assessor in, all finding that this person didn't have capacity to make a decision about their care needs on discharge, and therefore it affected their discharge destination. And then someone else came along and said, "You do realise you would be safer in a care home than you would be at home, don't you?" And she just said yes. And on the basis of that, that person thought she had capacity. So therefore it had to go to court of protection to have a discussion about whether this person did have capacity or not. But obviously that's a leading question. Don't try not to make suggestions as well, and reassure the person that you're not trying to trick them. Because sometimes people don't want to say, "I know that I'd be safer in a care home," because then they think you're just going to stick them in a care home. So if you can sort of reassure them that actually what you're trying to do is get their opinions about different options, then they might be more likely to sort of help with that weighing up aspect. And then remembering to empower the person whether or not they have capacity. So what is executive functioning? We talk about it quite a lot. It's a fragmented concept. It's really an umbrella term covering lots of different aspects of what we call higher functioning. So a really good explanation of this is thinking about a PA, or his executive secretary, who's trying to manage lots of different things, pool different aspects of information together, getting things done on time, sorting things out. So they are, or some people say it's like the conductor of an orchestra. So it's like attention, now I need memory, now I need planning or whatever, and they're pulling it all together. So I'm not going to go through all of this because I'm sure you'll know most of it. A couple of things I'll just pull out in case you're not aware of the terms. Goal maintenance is just being able to keep going towards a goal, so your behaviour, you're able to maintain your behaviour towards that goal instead of going off on tangents or getting distracted or forgetting what you're doing. Perseveration is when you get stuck on doing or saying something, and the opposite of that is cognitive flexibility. Confabulation is when your mind fills in the blanks. If you aren't remembering something, often we don't like those blanks in our memory, so our mind fills them in for us, but we don't realise. So it's not like lying, because we're not aware that we're saying something that's not true. But for example, might go in to see someone and they say, oh yeah, I've been to the hairdresser this morning, because they can't actually remember where they've been. But they believe they've been to the hairdresser when actually they've not left the house. And yeah, affect, flat affect, so somebody might present with quite a flat facial expression, flat prosody, so their voice is quite flat, especially after right frontal lobe damage. But when you talk to them, actually their mood's fine, they don't feel depressed. Versus labile mood, where someone can't stop themselves crying, or they feel they're crying too much, or sometimes laughing inappropriately. So executive functioning can be affected in anybody. You might have noticed it yourself if you're very stressed or you're very tired, that you might not be as good at planning, organising, pulling things together, or emotional turmoil as well. If you've had a bereavement or something major is going on in your life, you might find you feel a lot less organised, you can't actually do things as well. I've already said that. It is difficult to assess because of the fact it covers so many different aspects. So often we have to do different assessments. Paper and pencil tests can be useful to a degree, but actually functional assessments are really useful as well. So often it's those two parts, and that's where psychology and OT work really well together. So something like the multiple errands task, when you get someone out into the community, they're having to go into shops, buy things, stick to certain rules, is really useful. We had, way back when I was an assistant psychologist, we had someone who passed all of the paper and pencil executive functioning tests, and then we took him out into, it was in Aylesbury town centre, and we had a little route that we did the multiple errands in, and he just walked up and down. He didn't go into any shops. He couldn't get started, he couldn't initiate anything, he couldn't prioritise or think, how am I going to do this? He just didn't know where to start really, and that's when we noticed why he was coming to us and what difficulties he was having in work situations. Just to say that executive functioning does not equal executive capacity, they're two different things. So we cannot assess executive capacity by doing executive functioning tests. Awareness and insight are very important when doing mental capacity assessments. And as I said earlier, insight can be affected by brain injury, neurological conditions and dementia. So we can look at that by doing interviews with the person themselves, their family, staff who work with them, carers, or using questionnaires. So the family member might fill in a questionnaire and they fill in a questionnaire, and you look at the difference in the answers, and that sometimes really helps someone's insight because they trust their family member. Whereas sometimes if we're saying things like that, they're like, oh, I don't believe you. So Crosson et al. Have developed the pyramid model, which is hierarchical. So they think that you have to have intellectual awareness in order to have emergent awareness, in order to have anticipatory awareness. So intellectual awareness is when somebody can say that they have problems, and they know to some degree that it might affect their functioning, but usually they think they'll be okay. So that's the sort of person that say, oh yeah, I'll be fine. Emergent awareness is when someone starts to recognise they're having a problem while they're doing the task. And then anticipatory awareness is when someone says, oh, I won't be able to do that because of X, Y, or Z. There's another model out there, Togley and Kirk in 2000, had a more dynamic model. They thought it could sort of move around a bit more, and it's more, it can relate to things like belief in your own abilities, task demands, and context of the situation. And the feedback to the person can help with that. So someone with executive capacity problems may have intellectual awareness, but then they don't realise problems are actually happening during the task, or they might blame it on something else, like, oh, it's not my kitchen, I'd be fine in my own kitchen, and they can't anticipate they're going to have problems. Okay. So if somebody tells you one thing and then goes and does something else, don't always assume it's because they've changed their mind. It might be something else going on. So just coming back to that frontal lobe paradox again. And it's different from someone telling you what they think you want to hear, which does happen in capacity assessments as well, often due to ABI or dementia. And interestingly, the Scottish Act, which came into being before the MCA, states that someone can be incapable of making a decision if they're unable to act on it. So they have the action in the act as well. So the MCA does say you have to be able to use the information when it's required to make the decision. So, as I said before, with ongoing decisions, you're having to use that information every single time. So people might have many different reasons for difficulties carrying out the actions. As I said, somebody might have problems initiating something, so they can't get going with it, or they might just be impulsive and can't stop themselves from doing something different. They might not be able to inhibit responses or get stuck, or they might not be able to problem solve, or it might be due to poor emotional regulation, as in MAUD. So it's interesting to listen into what other people are saying about that person. For example, if staff say, oh, he just can't be bothered, actually it might be an initiation problem. If they say, oh, that person changes their mind a lot, actually it might be impulsivity. If they say, oh, they're just saying what we want to hear, it actually might be confabulation. Or if they say they give up really easily, and it could be due to goal maintenance difficulties. So assessing executive capacity, again, is different for one-off decisions and ongoing decisions. If you're doing a capacity assessment and the person is then doing the task immediately after the assessment, then it might not be as much of a problem. Also, things to check that there's not undue pressure from other people, and that's what's making someone do something different. Also, making sure there's no skills deficit or resource deficit there, and I'll talk about that a bit more in a case study I've got later. Involving other people who know the person well. Also thinking about the person's history of decision making. How did they used to make decisions in the past? Is this the sort of decision they would have made? Using functional tasks to see if they can put into practice what they're saying. And the NICE guidelines actually recommend that real-world observation of the person's functioning and decision-making ability should supplement any capacity assessment interview. So we're aiming for a holistic view of the person's abilities. So this is Vicky's case study. Desmond was a 56-year-old man, and when Vicky came across him, he'd had a stroke 4 years ago. He had a history of depression and excessive alcohol use. So straight after the stroke, concerns had been raised, but he actually self-discharged against advice. So the capacity assessment hadn't been done at that point. A year later, his house was in a state of disrepair and it was unsafe, and he was also in arrears for his utility bills. So at that point, a capacity assessment was done by social services and he was moved into a residential home. And he coped really well with self-care tasks and going out into the community on his own. He would always come back. However, he kept stating he wanted to go home, and he said he'll get help to sort out his house. So they then did another capacity assessment and decided he did have capacity and he was just making an unwise decision to not sort his house out. So Vicky met him 2 years later. He was still in the residential home, even though he'd been deemed to have capacity, so he could have left. Still stating he wanted to go home, but he hadn't made any steps towards making his house safe. Staff thought he was unmotivated and he didn't want to spend his money on repairs. So Vicky did a cognitive assessment and found he had difficulties learning new information and problems with language, attention, planning and problem solving. And in observations, just in conversation with him and on those assessments, he was also noted to have some verbal disinhibition, poor recall of previous discussions and confabulation. So for example, he said he'd been to the dentist to get some false teeth when he's actually not registered with a dentist and didn't have any false teeth. So the capacity assessment was a bit of a head scratcher because we're trying to work out what is the decision here, what are we actually assessing? And we thought, well, there's two things really. There's assessing his capacity to make a decision about repairing his house, but there's also capacity assessment around his care needs. So we were thinking he needs to understand the extent of work required in the house. He needs to be able to make a plan of action to decide on the first steps required. He needs to be able to act on the plan of his first steps and understand his support needs. And over the course of several sessions, it was obvious that he didn't understand the extent of the repairs, even though that had been discussed with him several times. He'd been out to the house to see it. However, with support, he could make a list of first steps to do before the next session. So he was sent off to do a couple of steps, and they were quite simple steps. And next session happens, he hasn't done anything. Again, there was some confabulation there. He said he'd lost his keys, his friend was on a cruise, he was blaming other people for things not happening. And he stated he didn't need any help with care tasks or repairing the home. He said, I'll get it done. So poor initiation, planning and cognitive flexibility and reduced insight all came into this formulation. And it was complicated by confabulation and goal maintenance difficulties. So there was a few things there to work on with him. And it was recommended that he had a financial capacity assessment, because does he actually have capacity to manage his finances, to make the decisions to spend money on his house or not? Okay. So other things we need to consider: communication. What level of communication they have. Do we need to get speech and language involved? Are there alternative ways of communicating with someone? Previous attitudes, values and beliefs. So somebody might have a belief about hospitals. I had a chap who was really defensive and didn't really want to speak to me. It came out that he just hated hospitals. He'd been told that he needed a hip replacement and he'd said, no, I'm not having that because I'm not going into hospital. But he then had a stroke and had to go into hospital, and he was desperate to get home. And with him, it was really building up that rapport and getting him to trust me enough to sort of tell me what he actually thought. Or people might hold rigid views about issues, as Elizabeth was saying earlier, about somebody with an eating disorder. But also other issues such as might be that someone who, taking one of Dan's examples from Learning Disability Services, a lady who was in the older adult range was saying that only men look after finances. So that was her belief about her money, and she felt that as long as they were a man, they could look after her money. And that's just how she'd been brought up. But she wasn't really thinking through, is that a safe person to be looking after my money? Also need to think about mental health issues. Low mood, anxiety and psychosis may all affect capacity, as we saw with Maud. And then psychosocial factors, including lack of assertiveness or deference. Again, so these are Dan's slides. This is something that comes up quite a lot when he's working with people with learning disabilities. So there might be undue influence from other people. That might be really obvious, like a threat, or it might be quite subtle, like fostering dependence on someone else, or withdrawing positive regard. So you might see that in families, for example, saying, oh, well, if you move over to that care home, I won't be able to come and visit you. So there is case law that supports people's religious beliefs, and there's quite extreme case law. I can't remember the date, but it's quite old. There was a Rastafarian gentleman who was in Broadmoor, so he had schizophrenia, and he was saying, so he had gangrene in his leg, and he was saying, I'm not getting my leg cut off, I need to be buried whole, because that was his religious belief. So it was taken to court, and the judge upheld that and said, well, actually, this has nothing to do with his schizophrenia. So coming back to the causative nexus that Elizabeth was talking about earlier, is the lack of capacity due to the impairment of mind or brain? And the judge said, no, even if he's going to die, that's his choice. He has capacity to make that decision because it's a religious belief. And actually, in the end, in that situation, it was cured anyway, and he lived. So he didn't actually need his leg chopped off. So that was a good outcome all around. There's also other beliefs that culturally are held, and that might be, so that's not part of religious doctrine, but they might guide decision making. So that might be a general cultural belief, or it might be a more niche culture like homeless culture, which again I'll come on to later. So it's not, we need to think about what cultural aspects that person's living within. And then beliefs arising from a specific experience. So again, one of Dan's examples was a lady who had been abused in a child's home, and then she didn't want to go into a residential home when she was an older adult because she had the belief that she would be abused if she goes into a residential setting. So we need to take these things into account and know where these things are coming from. We also need to think about social cognition. So we do need to take into account other people's intentions, emotions, and beliefs, and some people have difficulties with that. For example, people with autistic spectrum conditions, schizophrenia, or brain injury involving the frontal lobes, or people with frontotemporal dementia. So thinking about who would this decision affect? For example, if someone's writing a will and they want to leave all of their earthly possessions to one child, but there's another 3 children who are getting nothing, that person needs to understand how it's going to affect those 3 children, but also how it's going to affect the person they're leaving all the money to and their relationships with their siblings. Or if we see this quite a lot when someone's going home from hospital and they're saying, oh, my husband or wife will do all of that for me. And it's like, well, they work full time, so how are they going to manage that? And do you think they're going to get burnt out if they're doing all that heavy lifting and not really taking into consideration someone else's needs as well? When we're thinking about mood and emotional reactions, we think about subtle ones as well as more obvious ones, so the severe enduring mental health problems, but also thinking about mood, anxiety. And there's case law around someone who had a severe needle phobia, who needed blood taken, and they were deemed not to have capacity because of their phobia. So that's an impairment, a disturbance rather than an impairment of the mind. So thinking about how it impairs cognitive functioning, the imbalance in the weighing up process, and any distortion of reality from those mental health difficulties. Okay. When we're doing a capacity assessment, we need to make sure that the person has all of the relevant information. And we need to make sure that that person has it in a way that they can understand it. So we need to be thinking about cognition, communication level here. How can we make it easier for them? How can we enhance their capacity? So preferably using simple language with choices and implications clearly outlined. Usually we would do that over a period of time if possible, and then repeating it before the assessment, rather than just going in blind. And again, there's case law saying do not go in and with a blank slate approach, thinking the person should know all of this, because we would all lack capacity if we were asked to make a decision about a significant medical treatment, just because we wouldn't have the information. So that's not fair to be saying that that person should be making that decision without all of the relevant information first. Elizabeth's already said that, but risks of doing nothing is actually a decision in itself. Because if you choose not to have a medical treatment, there are consequences of that. So we need to make sure that people are aware of that. And 39 Essex is quite a good place to get capacity assessment guidance. So as Elizabeth was saying, talking about thresholds for different decisions. So I won't go through all of this. But it is useful to note the Court of Appeal ruling 2019 that stated case law is to be used as guidance for capacity assessments and can be expanded or contracted accordingly for the individual. Because I think this was around social media and internet use, and that had been put together as one, and this person wanted to go on the internet but they didn't go on social media. So that's when it was noted that actually that could be contracted to take out the aspects of the social media. And again, I won't go through this because Elizabeth had it, but one point in the care needs on discharge and discharge destination is that case was somebody with a learning disability, and therefore cost didn't come into it. So it's not in the case law. However, for someone like me, if I was deciding whether I wanted carers to come into my home or to go into a residential home, cost would be something that would need to be considered, and therefore it would be relevant information. So that's when we would expand that case law. So how do we introduce the assessment? This is quite an important part of the assessment, to make sure the person knows what we're doing and why we're doing it, and doesn't feel like they're being tested. So using simple terms in conversational manner, framing it in a positive way, so letting people express their views on the topic. And I think I've only had maybe one or two people that haven't wanted to talk to me and give their point of view across. And I think as a psychologist, because I'm hardly ever the decision maker, it makes it easier for people to talk to me because I'm sort of an independent person. Also, we might be supporting them to make a decision, so it might be a sported conversation around that they can then make the decision, and we don't need to go down the capacity assessment route. Or if we get into the best interests situation, then we'd be considering their views and values to see what's in their best interests if they're unable to make the decision for themselves. So we'd tailor it to the individual and be clear about the decision in question. So we might say something like, some people find it difficult to make decisions after a brain injury. We would like to see what you're thinking about the care you would need when you leave hospital. If you're able to make this decision yourself, then that's fine, but we can still offer you support if you require it. If we think that you're unable to make this decision yourself, we'll have a meeting that you and your family and the professionals working with you will attend, and we'll discuss what we think is in your best interest to make this decision. To do this, we'll take your views and what's important to you into consideration before making the decision. So you're giving them information on both options, so whether they have capacity, what will happen; if they don't have capacity, what will happen. And that's something some people shy away from because they don't want to sort of think about people not having capacity. But when I'm doing training for the trainees, I always say it's not a bad thing that someone doesn't have capacity. It's not a punishment. It's just thinking about, okay, how can we make that decision for them in their best interests then? And it doesn't mean that they're not going to get what they want. If someone wants to go home, they might still get to go home. So if you do have people that have difficulties engaging with you, try and make sure you're promoting that collaborative approach, that you're sort of finding out information rather than I'm testing you or I'm the expert. Being flexible and open-minded. And in one of the cases with the chap that didn't want to speak to me, he just didn't like authority and he saw me as an authority figure. So he just shut down with me and he would say things that he was going to do. He said, oh, I'll eat what I like when I go home, which was quite interesting because observations showed that family members had brought in inappropriate food. And as an experiment, we just sort of left it on his table and he never ate it. Or there was another one, he said, oh yeah, I'll be able to go to the toilet myself. But he was in a wheelchair. So I said, okay, why don't we go down to the gym and you can show me how you would get up to go to the toilet. And he said, oh, I don't want to fall. So clearly the insight was there, but he was just saying things because he didn't like me. So in that situation, we thought, right, okay, take myself out of the situation. And they had a really good relationship with the physio. Excuse me. But the physio had never done a capacity assessment before. So I was able to help the physio think about what questions to ask the patient, and that actually worked really well. So the patient was happy to talk to the physio about all these things, and he did actually have capacity. He was just playing up because he didn't like me. Or it might be that the person sees it as quite confrontational, face-to-face. So we have had a situation where my colleague took the person for a walk around the hospital and talked about it side by side. And this person had an autistic spectrum condition and found that a lot more comfortable than a face-to-face interview. So it's more informal, but he still knew what the assessment was looking at. So when I did my research way back in 2004-05, because I had to ask everyone the same questions, I had to develop a semi-structured interview. And then I found it so useful that continued using it clinically afterwards. So it's been adapted for clinical use in several different decisions now. One of the first things that you have to do as the assessor is establish the actual risks and issues surrounding the decision in question. If you don't know what they are, you can't ask the person about them. So we see this, I think it still happens actually, where social workers go on to wards, don't speak to the staff, go up to the patient, chat to the patient, and say, oh yeah, they've got capacity, they say they want to go home, and they'll do this, that, and the other. And it's like, well, they can't actually do that. But because the social worker didn't know those issues before they went to do the assessment, they weren't able to do a proper capacity assessment. So make sure that you talk to family carers, MDT members, getting all that information before the assessment. Looking at the person's insight into their problems, other things that may be influencing their capacity, and then directly questioning about the actual risks and issues to see if they're aware of them and they believe them to be related to themselves. Memory of awareness of safety advice that's been given to them. And also thinking about how is this going to affect you in a different situation. So for example, the research I did was about discharge destination and care needs. And sometimes people would say, oh, I know I'm in a wheelchair here, but when I get home, I'll be able to walk. Because they couldn't put themselves into that situation. And I thought that was really interesting. And maybe because their last memory of themselves at home is them walking around and doing everything, and they hadn't been home. But then I came across a lady who didn't have many cognitive problems, and this was quite more recently. And she was in a wheelchair, and she said, oh, I'm going on a home visit this weekend. And I said, oh, that's great. And when she came back, I said, how did it go? And she said, oh, I was really disappointed, actually. I thought I'd be able to go home and put a wash on and hang it out. And it wasn't until I got to the washing machine I thought, how am I going to do that? Which I thought was really interesting, because she didn't have cognitive problems, but she wasn't able to sort of think ahead and put herself into that situation. So thinking about risk awareness, problem solving in specific situations. So if, for example, somebody is having 4 care calls a day, what would you do if you needed the toilet just after the carers had left? And then some people will say, oh, I'll just take myself off. And others will say, well, I'll just have to sit there in a wet pad until the carers come back. But you can adapt it to the person's situation. Like if you ran out of cigarettes and you needed some cigarettes, but there's nobody else around, what would you do? Oh, I'd just pop down to the shops. Okay, but the safety advice was that you don't leave the house yourself. Oh, I'm sure it'd be fine. So you sort of can get an idea of how they're weighing things up. And looking at the pros and cons of alternative options. So when you are doing an assessment, as I said before, try and use open questions. However, if you do have to ask closed questions because of their communication, try to turn the question around so you're asking both versions of it. And as speech and language therapists will tell you, try not to put a negative into there. So don't say not or don't, because that can be difficult for people to pick up and they just see it as a positive statement instead of the negative. So you might say something like, can you get to the toilet yourself without help? Or can you get to the toilet yourself? Yes. Do you need help to go to the toilet? Yes. So you'd be thinking, well, why are you saying yes to both of those? And you might look at that a bit more. So obviously you're looking at a yes, no answers. So we do need to promote capacity. It's a statutory responsibility under the MCA. And the Equality Act also recognises that we do need to take steps to help people overcome barriers by making reasonable adjustments. So even simple things such as picking the best time of day for the person, thinking about medications, sundowning. Some people just don't wake up well and don't want anything happening before midday, for example. Minimising distractions is a really obvious one, but I have seen people trying to do a capacity assessment with the telly still on in the background. These can all help people. Other things that have been found to be useful, breaking information into chunks, so small chunks of information so somebody can retain it a bit better. Using non-verbal demonstrations, so I've had an OT actually get down onto the floor and say, okay, well, how would you get up if this was you? Using quizzes and repetition. Different types of media as well, pictures, videos, writing things down for people. And it is okay to give people lists of pros and cons. Some people think that's cheating, but actually you can say, do you think this is a benefit of this option, or is it something you dismiss? So when we're doing that with somebody with language difficulties, we also chuck in some totally random ones that have nothing to do with the decision. So we have 3 columns, benefits, difficulties, and or we sometimes call them bad things about that option, and not related. So something like being able to buy flowers every day when you're at home is not really related to the care needs. So just making sure that they're understanding what is related to the situation. and using decision trees as well. So when I was talking about the PEG earlier, oh, I've got a decision tree coming up. I'll let you see that in a minute. It's also really important to use interpreters whenever somebody's language, English isn't their first language, because they might be fine in conversation, but if we're talking about quite abstract or difficult, complex concepts, they might not actually be taking in all of that information in different language. Involving familiar people who they can trust in conveying that information and providing support is really useful as well. Friendly environments, perceived absence of prejudice, and being encouraged to develop confidence have all been found to help as well. So I find this really useful checklist quite a long time ago now. Unfortunately, it's no longer available, so I've taken the link off, but I've just sort of summarised it. I'm not going to go through these, but you will have them on the slides. And it breaks it down into all the different aspects. Just one thing I'll say is about non-desirable options. So this comes up with people that don't want to go into a care home. They say, well, I don't even want to discuss that. But actually you do need to. And sometimes it comes up in best interest meetings as well. If the person says they want to go home, putting that on the table as one of the options to discuss, even though the family are saying, well, that won't work. We can't even support that. It's like, yeah, but let's look at it as an option and look at the pros and cons of it. Oh yeah, check reasons for choices as well. So if you're worrying about a bus, getting on a bus, you might refuse a hospital appointment, but actually there might be an alternative to that. And is the service user talking to someone they feel able to tell as well? So that's important. So that man I was talking about didn't feel able to tell me. So it's good to switch the assessor. So that's just an example of a decision tree. Simplified, obviously, but it is about having a PEG and thinking about, okay, at the moment your nutritional needs aren't being met. So we've got two options. You can have a PEG or you don't have a PEG. If you don't have the PEG, in this case, eventually the person was going to die because they weren't getting any nutrition into them. But also, if you have a PEG, it doesn't mean everything's rosy. It might mean that you're able to engage in rehab and improve, or it might mean that just actually you're a bit more comfortable, but you don't improve physically. So trying again to look at those options yourself and thinking about pros and cons, it's not always as obvious. So just a quick one from Jane Jolliffe, who was a speech and language therapist in the learning disability team. She's retired now. So I've borrowed her slide. And she's actually written a really nice chapter in our book, which goes into loads of details. So if you're interested, have a look at that. But this is just a quick one about keeping things short and simple. One idea per sentence. So the doctor will give you medicine, you will go to sleep, rather than the doctor will give you medicine and then you will go to sleep. Always saying what you mean rather than what you don't mean. So banning the no's, the nots, the don'ts. You're staying in rather than you're not going out. Or the money has all gone rather than there's no money. As we sort of become more legalised and solicitors become more involved in our processes, we do need to make sure we're documenting everything properly. So we did an audit on the INRU and found that people weren't necessarily documenting things properly. It's really useful to write down all the questions you've asked and the person's answers verbatim. And putting that into the person's notes, as well as any capacity form that you're having to fill in, that you're being asked to by your trust. And so that something like a semi-structured interview where you've thought out your questions beforehand is really useful, because then you just need to write down any tweaks or additional questions and not writing loads. And be prepared to explain your reasoning and rationale for your opinion to others. And remembering it is just your opinion. We can only give opinions. The only person that, or the only body that can say whether someone does or does not have capacity, finally, is the Court of Protection. However, we are protected by the MCA as long as we have followed due process. Our opinion will count. And it only has to be 51% sure. So it's the balance of probabilities. So you might say, yeah, I'm 51% sure they have capacity or don't have capacity. So it's not something that you need to worry about. It's just like another clinical assessment, like other ones that you would do. And then fill in your official capacity documentation as well. So good documentation should include all of the following. I'm not going to go through it. Quite important about the causative nexus. That's something that came up quite a lot, that people weren't relating the lack of capacity to the impairment or disturbance in mind or brain. And on putting recommendations even if the person does have capacity. So when I did the audit, these were the things that were often missed. Thinking about the threshold of understanding, the level of understanding required for that decision. What does the person need to understand, retain and use and weigh to make the decision? Adequate evidence for each 4 parts of the functional test. People weren't writing down what the person had said or just asking a few questions instead of fully exploring it. Ways in which the person tried to enhance the person's capacity. Stating if the impairment is permanent or temporary. So if it's a temporary impairment, can the assessment be put off until the person might have regained capacity? Recommendations weren't always in there, and that causative nexus as well. So I've just got one last case study to finish off. This was, John was a 39-year-old man who was on the INRU, and he had experienced a traumatic brain injury due to an assault 4 months earlier. So he had a large frontal skull fracture and large parenchymal bleed with intraventricular extension. He'd lived on the streets for 20 years and he had a history of multiple drug and alcohol use. When we did the cognitive assessment, we found he had difficulties with his memory, processing speed for complex tasks, strategy use and verbal fluency. He had visual difficulties, but he refused to wear glasses. And that was quite interesting when we're thinking about homeless culture. He said it's an obvious sign that he's vulnerable if he's wearing glasses. It's like an advert to beat him up, take his glasses off. When he first came onto the ward, he had severe anxiety and moderate depression on the hospital anxiety and depression scale. But that sort of settled over time to what he called normal mood, which was 5 out of 10 he rated after about 4 months on the ward. So quite a few capacity assessments for John. We had to do a capacity assessment about taking drugs and alcohol after a brain injury, because obviously the risks change once you've had a brain injury, so there's extra information he needs to know about. Managing his benefits and support needs on discharge. So he was buying food for friends on the ward and getting takeaways frequently with his benefits. And this was sort of what alerted us to thinking about a financial capacity assessment as well. That was quite constrained because he was in hospital. I did the financial capacity interview with him, went over to the shops, got him to find things, find out the cheapest, the most expensive, things like that. We've got a great shop near the INRU. They're very good and put up with us quite a lot. We're taking patients over there and doing these sorts of things. I watched him taking money out of the cash point to make sure he was able to do it, checking out he was aware of how much money he had and what he was spending. And that was about as far as I was able to go, unfortunately. So we found that he did have capacity for drugs and alcohol after brain injury. He was able to take in that extra information, and he'd taken them for so long and had quite a few friends who unfortunately had had quite serious consequences due to them. However, he didn't have capacity for his support needs. He needed support with help in the kitchen and with community access, including shopping. And we also thought that actually he needed some structure to his day to stop him going back to the alcohol and drugs, because he said he didn't want to. He was willing to accept help. So when we're talking about buying food for all his friends on the ward, he said that's what you did if you were homeless. If you got money, you would spend it on everyone. And then when they got money, they would do the same. However, he was aware that there was a certain point he had to stop spending, and he had this figure in mind that when he got to that point in his bank account, he would stop spending, stop having takeaways. He knew they were expensive. He knew he needed money for when he left hospitals, and he was actually getting mini statements out to check on his bank balance. However, because he'd been on the streets for 20 years, he had absolutely no budgeting skills whatsoever. So that was a skills deficit that we felt that we had to address, and rather than saying he didn't have capacity. And his visual problems means he needed support accessing the cash machine as well. Sometimes he couldn't quite see what it was saying or which button to press. So I suggested that he would need further assessment in the community, thinking about budgeting, paying bills, stuff like that, after he'd been in the community for a couple of months. So that's the book I was mentioning. So we tried to take a multidisciplinary approach to it. So there's chapters by OT, speech and language, nurses, psychiatrists, solicitors, lots of psychologists, but from different areas, older adult, learning disabilities, brain injuries. And we've also got a website with lots of links of all the case law references, etc. In there, and the my structured interviews are on there as well. So something else I was just wanting to bring up before I stop is, so this is something, this is what we call the citywide form. When I'm talking about documentation, this was developed in 2014 by Emma Fowler at the Manchester City Council. She was in the safeguarding branch, in conjunction with myself and Dan Radcliffe, and input from other teams. And then it was updated in 2017. So it was, everybody had bought into it. So the what was then Central Manchester Hospital, South Manchester Hospital, Manchester Mental Health, Pennine Acute, and the City Council. So it was agreed that we'd all use the same form. But I think over the years it's been lost, and then different trusts have decided to use their own forms, and actually they're often not as good as this one. So I just thought I would bring it up and just let you see it. We still use it in MFT. So thinking about the decision, the reason for the assessment, threshold of understanding, who have you consulted, support given, diagnostic test of capacity, additional factors beyond the skills of the person, then the functional test of capacity. Interestingly, more recently, people are saying that you should go for the functional test first and then the diagnostic. So it's only if someone's unable to make a decision that you would then think, is that linked to their mind or brain? And then, so we've got the causative nexus there and conclusion, and you put in all your evidence as well. And then recommendations as well. And then you can append your semi-structured interview or whatever to the end. And then there's lots of guidance as well. So if anybody wants me to send you this, I think Killian's actually got it, so it would be quite...
I'll attach it to the slides.
Oh, brilliant, yeah, because it is really useful. There's also a best interests one as well, which we used less, but it's quite good to have.